Welcome back. I'm Ian Masters, and this is Background Briefing, available 24/7 at backgroundbriefing.org. And joining us now is Michael Greenberger, the former Principal Deputy Associate Attorney General at the United States Department of Justice, where he supervised work on security matters. He's the founder and director of the Center for Health and Homeland Security at the University of Maryland, where he also teaches constitutional law. Welcome to Background Briefing, Michael Greenberger.
Thank you, Ian.
So it's extraordinary that in his majority decision, Samuel Alito talked about how divisive Roe v. Wade has been. But the divisions in this country are just beginning. There's not, what happened in the last 50 years is nothing compared to what is happening now. So it's a very odd sort of logic that's coming out of this majority opinion. And the dissent from the minority, the three liberal judges that are left, was pretty powerful, and basically saying it's all about power, that power, not reason, is the new currency of this court's decision-making. So is this really just the beginning of what we could describe as government by judiciary, that this Supreme Court of ultra-conservatives or very conservatives are now about to flex their muscle even further? You've got Clarence Thomas saying that he wants to move against contraception, intimate sex between same-sex couples, and also gay marriage. So what's your sense, Michael? Are we just at the beginning of more and more radical rulings?
I'm afraid that is the case. And any assurances that are given in these decisions, it is difficult to put much faith in them because you must remember that the Trump appointees, Kavanaugh, Gorsuch, and Amy Coney Barrett, when they were testifying to the Senate Judiciary Committee, they said that Roe v. Wade was settled law, and that gave assurances to enough senators, especially Susan Collins of Maine, that they would not disrupt Roe v. Wade, which is 49 years settled law in the United States. In 1992, there was a very careful reexamination of Roe in the Casey case, and three Republican justices, Sandra Day O'Connor, Kennedy, and one other, reaffirmed Roe and allowed it to sustain itself. So anything that we're told to give us some assurance that a line has been drawn and they will go no further simply cannot be believed. And I think that it is incumbent on those of us who disagree with these opinions, because they really are a reflection of raw political power, to be involved in regaining the political upper hand. And that starts with the midterm elections in November.
Well, both Senator Manchin and Senator Susan Collins have complained that they feel that they were misled by both Gorsuch and Kavanaugh. But that would indicate that this is, in fact, as the dissent from the three liberal justices indicate, that this is really about power. There's certainly no intellectual consistency here, is there? It's just extraordinary to think that there's a doctrine of originalism or textualism, I guess. I don't know. You can tell me what the differences are, Michael. But the long and the short of it is that are we living under the tyranny of a kind of self-righteous minority who honestly believe that the only things that are constitutional are what happened in 1868, and that everything else is progress that's been made doesn't matter? We're just, literally chiseled in stone. We're stuck with what life was like in 1868 as opposed to 2022.
Well, any assurances that we're going to abide by what life was like in a certain historical period, I really are not worth very much. I mean, after all, Roe was a 49-year-old decision, and according to three of the justices who overruled it in their testimony to the Senate Judiciary, said it was settled law. In this New York gun control decision, where the court upset the Sullivan Act, which was passed in 1911, 110-year-old law that allowed New York State to permit dangerous weapons outside the home. We're now told that was not enough historical background, and the court moved the goalpost to look to, the Wild West as to a standard of how states should be able to control dangerous weapons. There's no consistency, I think, in fairness. There's no consistency here. And when one is left, when one looks at the array of decisions, to see that this is just what the 6 justices on the court want to do at any given point in time. And, the assurance, for example, that overruling Roe will not affect contraceptions or same-sex marriage or things of that sort, I think are not worth anything. And I think we have to brace ourselves. I mean, again, in 1965, Connecticut outlawed the use of contraception. And the Griswold case, written by Justice Goldberg in 1965, said, as a matter of constitutional privacy protection, the state should not tell individuals how to deal with their private matters. And Thomas is very clear in his decisions that, he's going to go after contraception, same-sex marriage, et cetera, that there's no hard line to what has been done, even though some of the other justices would like you to believe there is. We cannot be assured by anything that's told us by these 6 justices. And again, this is political. And the only resolve for those of us who are unhappy and think these are wrong and anti-constitutional decisions is to throw ourselves meaningfully into the political process, not only at the federal level, because at the state level is just as important. The decision on Friday tries to assure us that a hard line has been drawn at what the decision held, and that we shouldn't be worried about contraceptions or same-sex marriage, et cetera, that these justices won't go there. But Thomas is signaling clearly he wants to go there. And the assurances given by these justices are the same assurances they gave the Senate Judiciary Committee when they were confirmed. Roe v. Wade was settled law. 3 of these justices said that. And yet the first chance they get, they overturn Roe v. Wade, a 49-year-old precedent.
And again, I'm speaking with Michael Greenberger, the former Principal Deputy Associate Attorney General at the United States Department of Justice, where he supervised work on security matters. He's the founder and director of the Center for Health and Homeland Security at the University of Maryland, where he also teaches constitutional law. And when President Biden signed the bipartisan gun safety bill on Saturday, he was asked whether the Supreme Court is a broken institution, and he replied, I think the Supreme Court has made some terrible decisions, but he doesn't seem to be interested in what some people describe as packing the courts. So is there any other alternatives? I mean, can you get term limits on these justices? Is there anything that we can do? I mean, the only thing that really erodes their authority is what they're doing, but they still will hold on forever as long as they're alive, right?
Well, as things stand now, that's right. But again, this all goes back to politics right now. And the politics are, what can a Democratic Senate, for example, do? The midterm elections threaten the posture of the Democrats in the Senate. It's 50-50 now, and the vice president breaks ties. It is just very important that the Democrats hold on to that Senate majority with the vice president voting to break ties. And if in fact these midterm elections can increase the majority in the Senate, yes, things can be done to control the Supreme Court. You know, Roosevelt, in the early New Deal, the Supreme Court undercut right and left much of the New Deal legislation. And in 1936-37, he devised the so-called court packing concept, and legislation was prepared to add justices to the court on some algorithmic method, depending on when justices turned 70. There was the so-called switch in time that saved 9. Justice Roberts, a Republican justice from Pennsylvania, switched his vote in later New Deal decisions to uphold the New Deal legislation, and therefore the court packing wasn't deemed to be necessary. And I must tell you in all candor, court packing historically became a sort of a no-no. It's something that liberal jurisprudence looks down on. But I think one thing that has resulted from Friday's decisions is that many people I know who were active and politically, or either as politicians or as policymakers, are now, based on what happened Friday, they are turning back to court packing or limits, not as protective of our rights, would be limits on the terms of justices. I think court packing is the most obvious thing. I mean, after all, you've got to remember that George W. Bush was not popularly elected. Donald Trump was not popularly elected. And I believe they have 5 of the 9 justices on the court. Merrick Garland, who was nominated by President Obama, was deprived of even a hearing by the Senate Republicans. And with a year left before the election, he never got a hearing. And the Democrats are deprived of having the ability to put Merrick Garland on the court. So there's plenty of rational thinking that can be used to say you've got too many of these justices who were appointed by presidents who did not win the popular vote. And Merrick Garland was prevented for 1 year from even having a hearing held, and that justices should be added to the court. That will take Democratic control of Congress. That means we've got to hold the Senate and the House in the midterms. And one hopes that the reaction to what happened on Friday is so dramatic from the Democratic side that there will be a renewed push and a success in keeping the House and holding the Senate in the midterms. And once that happens, we can turn to policies that will make the court a court that more represents the American people.
So, Michael, just in the last few minutes, you brought up the New Deal and how the Supreme Court was stopping FDR at a moment the country was in terrible crisis with massive unemployment and poverty and starvation. And they were basically sticking to this doctrine, the non-delegation doctrine, which is now coming back. Stephen Bannon, former President Trump's strategist, has famously said that they want to deconstruct the administrative state. Well, they are going after. I mean, as bad as striking down Casey and Roe are, and in particular the day before, Thursday, striking down the ability of blue states to have their own gun safety rules. In other words, states' rights don't apply for guns, but states' rights now apply for a woman's uterus. I mean, it's crazy. And frankly, had this ruling been in effect on January the 6th, all of those people that stormed the Capitol, many of them would have been armed with assault rifles, and God knows what kind of mayhem would have happened. So there's just no logic to what's going on. But I'm told by a lot of constitutional lawyers that this is just the beginning, that if they really go full on into basically government by judiciary with the non-delegation doctrine driving them, then, the EPA will be out of business. It won't be able to regulate anything to stop global warming. They've already gone after OSHA and the CDC, and all government expertise will be overridden by these unelected judges.
I think your point is very well taken. As bad as the cases were on Thursday and Friday of last week, there are hints within the conservative jurisprudence of systemic changes in the way we govern ourselves that will result in even more dramatic injustice. The non-delegation doctrine was used twice by the Supreme Court in 1935, and the essential theory of that is that the Congress cannot delegate its legislative authority to administrative agencies. It was used twice in 35. In one instance, it was used in a way that was arguably quite proper, but your point is well taken. The doctrine as enunciated by Steve Bannon, there's a Fifth Circuit case that attacks rulings by the Securities Exchange Commission. The doctrine as enunciated by them is that an administrative agency has no power to develop its own law because in doing so, it will take away the power of Congress, which is by the Constitution given only to Congress. Now, you don't have to be a thorough political scientist to know that administrative agencies are given a mission by Congress to fulfill certain objectives, but the expertise in carrying out those objectives require administrative expertise. So our administrative agencies in rulemaking and adjudications fill in the rules in a more thorough manner. That's the way things have operated forever, with maybe some exceptions in the anti-New Deal court in 1935. So yes, we're already seeing that. The Fifth Circuit took away or declared invalid anti-fraud activity by the SEC. And if the Bannon, Gorsuch, and Gorsuch, by the way, is also given hints that he would adopt the non-delegation doctrine, it essentially would tie all administrative agencies in knots, and they would not be able to act if that doctrine finds its way into Supreme Court jurisprudence. And there are enough evidences of that happening right now that we should be worried. The other thing systemically that is worrisome is the court is giving hints that if state redistricting of congressional districts is challenged, that the only party that can challenge that are the legislators themselves, not the state attorney general, not private citizens. That legislators who create the inequities in the congressional district would have the only standing in court to challenge that. And we see across the country making voting so hard that if the average person cannot go into court to challenge that, that is going to be fundamentally damaging to the democracy.
Well, Michael Greenberger, I thank you very much for joining us here today.
Nice to be here, Ian.
And again, I've been speaking with Michael Greenberger, the former Principal Deputy Associate Attorney General at the United States Justice Department, where he supervised work on security matters. He's the founder and director of the Center for Health and Homeland Security at the University of Maryland, where he also teaches constitutional law. This has been Background Briefing. I'm Ian Masters. I'd like to thank producer Graham Fitzgibbon and assistant producer Asher Price. If you missed any of today's program and would like to explore our vast archives, you can find us at backgroundbriefing.org, where we include extended interviews searchable by topic and have made it easy for you to sign up for daily email updates that provide links to resources, articles, and books discussed on the program. Also, you can find links there to subscribe wherever you get your podcast, and we also encourage your ratings and reviews on these platforms. Find us on Twitter and Facebook at Ian Masters Media, and please do help us reach more listeners by sharing this program with friends, family, and colleagues. And to help us sustain this program into the future and assure it remains free to all, please take a moment to support us by going to backgroundbriefing.org/donate or to publictruthmedia.org, where you will find our non-profit Public Truth Media Foundation, where your tax-deductible donations, large and small, keep us broadcasting. And I'll be back again tomorrow with another Background Briefing at backgroundbriefing.org. Bye for now.
next door in 305. Took the kids to the park and disappeared by 9:30. Who'll ever know how much she loved them so? That dark night alone in America. A quiet voice was singing something to me. An angel song about the home of the brave in this land here of the free. One time, one night in America. Four small boys playing ball in the parking lot. A preacher, a teacher, and the other became a cop. A car skidded into the rain, making the last little one to say, one more light goes out